We are straight away moving to the next session that is on rule of law. I cordially invite Akhila Randeniya for the context setting. He's a research analyst at Advocata Institute. Please put your hands together to Akhila Randeniya.
Good afternoon to everyone. So for my portion of the context setting, what I've done is I've taken the findings of the report and I've made it, put it into more digestible, hopefully more digestible bite-sized pieces so everyone can understand what was exactly said and exactly what aspects of rule of law the report refers to and what the panel will be discussing. So there are three areas of discussion for today. The first is the stability of the legal framework, and the second refers to case backlog, court proceedings, and statistical record keeping. And the third is about the enforcement of property rights. So where do we currently stand now according to the report? First and foremost is that the rule of law governance indicators that are being used globally have been stagnant for quite some time in respect to Sri Lanka. Secondly, court systems have been suffering from poor resources, and I'll show how that links into the case backlog system problems that we have. And we also have a sort of lack of constitutional recognition for the separation of powers, and this is something that was identified in the report. So regarding the current world indicators on the rule of law, so the World Bank CPIA and the World Justice Project and the World Bank separately has also adjudicated that the enforcement of a contract takes more than up to about 1,300 days. And as you can see, Sri Lanka we have stayed stagnant, and I don't think that that's a great thing because as you will see throughout this presentation that the rule of law is kind of important when we're talking about economic governance and stability. So let's move straight into the court system and how the resource allocation system works right now. So in status quo, the system is unable to keep up with the flow of cases entering the system due to antiquated processes and a general failure to make use of technology in the case of in case management and assistance of case management. The report also found that judges are also consumed by administrative tasks of the court and not just adjudicating on cases as well, and that causes to the backlog and also the additional cases that are coming up day to day continues to the adding up to the backlog problem that we have. There also is absence of data and publicly accessible registries. This also creates another vulnerability, and land disputes are also regularly cited as the source of most of the numerous cases that are protected. So let's look at the lack of constitutional recognition for separation of powers. So the report by the IMF cites two cases upon which the UN Special Rapporteur report in 2017 found that the independence of judges in some aspects of safeguarding judicial independence could be enhanced. And separately, it also cites the International Commission of Jurists. And there's a case study regarding this. Essentially, it was when the Supreme Court found it put forward an interim order issued by the Supreme Court, which asked the Finance Ministry Secretary and the Attorney General to not withhold funds for local government elections. And this resulted in a member of Parliament requesting the Speaker of Parliament to refer to the conduct of the judges of the Supreme Court who gave this interim order as a breach of parliamentary privileges, and the Speaker accepted the request and made referrals to the Parliamentary Commission. And there was in a separate instance, the State Minister of Finance then reiterated sentiments to say that it was a serious offense to implement the interim order before hearing the privilege issues by the Parliamentary Committee on Ethics and Privileges. So that being said, let's move on to the stability of the legal framework. So unfortunately, the only constant we seem to be seeing is change. Traditional legal systems are subjected to substantial amendment, and I will show that in my next slide. And secondary legislation and regulations haphazardly issued with very due diligence. And what I feel like, personally, the biggest issue is that there's very or little to no public consultation when laws are being drafted and laws are being passed. So if I can draw an example to how the constitutional amendment works and how this little dance worked. Initially, the 18th Amendment removed significant constraints on political power and authority. And then we had the 19th Amendment, which reverted back to the provisions of the 17th Amendment. And then we had the 20th Amendment, which once again removed these constraints. And then we're back now with the 22nd Amendment, which reinstates the Constitutional Council, which some might be saying is a band-aid solution. So as you can see, we've had about 3 or 4 amendments that deal with the same thing. So like I said, this is the absurdity that we're dealing with when we look at the stability and the substantial amendments that go through the law in Sri Lanka. By the end of March 2023, we had 54 new amendments on UX being processed. By the end of March 2023, we had 38 policy approvals received, and so on and so forth. So now I'm going to be moving on to what can be considered the meat and potatoes of the report. It spent a significant amount of its time talking about the case backlog and how this could be helped, and what essential problems that are in the system. So if I can give you a simple breakdown of the court structures, this is what it looks like. And then moving on. So interestingly, we have a perpetual cycle of courts trying to address backlogs, but they're unable to clear out the current cases, and that creates like a sort of a domino effect where you can't clear the backlog of cases, but you also have new cases spawning every day, and that only adds to this mounting pressure that is put on the justice system. Then there's also an issue of how lengthy court proceedings and court processes leads to people avoiding of courts when it comes to enforcement of credit agreements and contracts as a whole. And what's sad is that the general consensus among the international investor is that it's unattractive to do business in Sri Lanka. So if I can draw your attention to an example, right? So if you look at the District Court of Colombo, and this is where some of the most financial institutions are based, there are 45,000 pending cases involving the recovery of money from broken contracts. On average, 10,000 such cases are registered each year at this court. And at the time the report was published, there were currently only 10 judges handling about 2,000 cases each at any given time. The table that is attached here shows the combined case flow for municipal and district courts. So as you can clearly see, the case backlog is overwhelming and is creating a pull-down effect in the ability to process incoming cases within a specified time period. Now, moving on to the administrative processes that weigh down judges. The Ministry of Justice points out that there are 15 judges per million of population. For comparison, India has around 21 judges per million population. We also have an issue with registrars carrying out a dual role of fiscal deputies and for contract enhancement, which is taking time from the other duties and responsibilities. There are also a lack of research assistance in higher courts. So the remedies that were suggested by the report is that we establish a special court to clear the backlog of cases and to utilize registrars and administrators in a more efficient manner. So the backlog could first be defined where you move into a period, or you set a predetermined date by which these cases would be handled separate processes with a heavy utilization of ADR, that is alternative dispute resolution mechanisms, such as mediation, conciliation, and arbitration. The cases post that date, the present cases, can then be handled by allowing the current system the time and standards and guidelines to carry out these cases. So, it on average takes about 6 to 7 years to enforce a contract in Sri Lanka, and there are severe delays, and the delay is the norm. Money recovery matters are the most common cases in High Court. And a 2014 National Survey of the Bar Association of Sri Lanka highlighted court delays, procedure, and corruption as extremely serious and impact Sri Lanka's attractiveness to foreign direct investment. And this is a recurring theme that we see in the report, is that the time it takes to solve a case in Sri Lanka really hinders our economic activity. So these are some of the remedies that were presented in the report. I'm not going to read them all out. In general, so if I could summarize it, is that access to information is limited and legal information is currently dispersed and not in a widely accessible way and in a usable format to help advance the general literacy of the general public. So, like I said, there is also an inadequate statistical collection and the professionalization of this sector. There's limited capacity of the Judicial Services Commission. The appointment of senior judges has very little or no clear, transparent processes. There's a lack of transparency as a whole within the court system, and this is something that the report reiterates. So, let's move on to the enforcement of property rights. There is a clear lack and there's a clear lack of decisive land policy with multiple agencies responsible for certain aspects of the land administration processes governed by their own acts and regulation. There is no legally empowered land use policy. Sri Lanka has a complex legal environment, as we know, for the administration of land with laws promulgated at the national, regional, and institutional levels. There are multiple sources of law, and there's no clarity on the devolution of responsibilities that exist in these situations. And the process of land administrating therefore requires consultation of multiple laws, often introduced at the time of independence and in absence of a clear and uniform legal framework practiced by all institutions. So if I could just put it into numbers, there are 50 land registries managed by the Registrar's Department of the Ministry of Public Administration and Management. There are 65 acts and regulations that influence title registration through multiple agencies. And once again, there's a duplicity of efforts and duplicity of laws that leads to a bit of issues when it comes to enforcement of property rights. So in summation, land disputes take forever to resolve. It takes an average of 10 to 20 years to solve a case, and district courts have 650 plus cases, some that go on for 40 years or more. So the remedies that are suggested in the report is that we use mediation. We streamline the land administration ecosystem, and we switch to a single centralized data collection system. So now I'd like to summarize the recommendations that are given in the report. The first one is that we introduce a specific procedure for adequate public consultation of new legislation. And the responsible party for that is that it's either the Attorney General's office or the Ministry of Finance. As you can see in the by when column, that was when the IMF suggested that we have these recommendations implemented, but unfortunately time has passed and there's been progress, but very little when it comes to these notions. The second is to set up a specialized court for clearing a backlog of cases, like we said before, and the responsible part is the Ministry of Justice. Next is to essentially expand the skills available to the Judicial Services Commission. It's so that they can better enhance their ability to carry out their functions and define potential options. This is the responsible party for this is the Ministry of Justice and or the Judicial Services Commission, and it's to be implemented, or at least recommended to be implemented by the end of this year. The next is to introduce a mechanism for areas to improve efficiency of commercial claims, including reviewing current court processes and and encourage settlement when appropriate. This is to be carried out by the Ministry of Justice, and it should have been implemented by April this year. Next is to establish an online digital land registry and publish on a designated website reports and progresses on the implementation of this plan for registering and titling all state land. And this is to be carried out by 2024 December by the Ministry of Lands. So that concludes my presentation. Thank you all for listening, and I hope you have fun listening to the panel discussion.